I'm okay with him enriching himself in all the direct ways, but this seems reaching, and didn't he break that record with taxpayer help? So I just have a problem with him then saying, I can prevent all of you from ever talking about Chuck Yeager outside of news reporting. No advertisement can ever refer to Chuck Yeager as having broken the sound barrier.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
In the United States District Court for the Central District of California, General Charles E. Chuck Yeager, I guess, and General Truck Yeager Inc., okay, that's his business, sues Airbus, Airbus Defense, Airbus Helicopters, Airbus SAS, so basically all the different forms of Airbus companies. Airbus, if you're not familiar, is the competitor to Boeing. They're the first or second largest aircraft manufacturer, like airline, like Boeing 747 or Airbus A320 or A380, etc. Some of the largest passenger aircraft, and I guess some of the largest cargo aircraft in the world, are created by Airbus. So that's who's being sued here. And remarkably, it's not just anybody who's suing, it's Lincoln Bandlow, who you may remember from Strike 3 Holdings fame. He is the lawyer that is representing Greg Lansky and Strike 3 Holdings, and for adult entertainment production companies who sue by the thousands across the country in various district courts wherever they can get favorable rulings. And they file mass litigation, so thousands of lawsuits by dozens at a time, every month or so in these various districts, and they pursue piracy via John Doe. I would call it BitTorrent litigation. It's litigation where the piracy litigants are accused of using BitTorrent, and BitTorrent exposes your router's IP address, basically, unless you've used some kind of VPN and even then, that's not legal advice, by the way. Like, the VPN can fail, and that can also be a bad way to try and commit piracy. So I definitely am not recommending that people commit piracy, but in this particular kind of case, people commit the piracy without any sort of protection for their IP address, and courts have said that if you see infringement on an IP address, well, then you can sue for it, and you can get the subscriber's identity, and you can then conduct an investigation into whether the defendant or subscriber is the defendant, or whether someone else in the subscriber's household is the defendant. And all this is perfectly legal and fine, and it's pretty egregious, in my humble opinion, but it's not illegal for Lincoln to pursue the cases or anything. We just don't like it from a moral sense. We don't like the high damages for such a low damage act. Now compare that he's representing Chuck Yeager, and you might see why I'm concerned. Is it really that already, before I even told you what they did, do we really trust Lincoln, the plaintiff's lawyer, to accurately represent what happened to Chuck Yeager here? And so he's accusing Airbus of violations of California Civil Code 3344, which I believe is something to do with the right of publicity, because then there's a common law right of publicity violation under here. The Lanham Act would be for trademark and common law trademark, and further federal trademark, which would probably be under the Lanham Act as well. And there's claiming false endorsement. So you can already get an idea. The accusation is going to be that Airbus advertised using Chuck Yeager in some way. And let's see what the details are. Plaintiffs Chuck Yeager and his company, by and through their undersigned attorney, Lincoln Bandlow, hereby claim against defendants Airbus. They claim that General Yeager is one of the most famous pilots of all time. He has flown around the world as the pilot who conquered the speed of sound. Indeed, he has flown at twice the speed of sound. As a result of his recognizable and well-known identity, General Yeager has been retained to provide commercial endorsements for selected companies, and they have paid substantial compensation for his services. Thus, using his name, particularly in connection with any form of aircraft, is incredibly valuable. This case is about the knowing and intentional theft by defendants of that highly valuable commodity. So they go into explaining how General Yeager is a retired officer of the United States Air Force. They explain that he was a fighter pilot in World War II, eventually a test pilot who broke the speed of sound, which is referred to as Mach 1. He also exceeded the sound barrier by 2.4 times, and he's famous for these things. He has commanded the U.S. Air Force Aerospace Research School, the 405th Tactical Fighter Wing, the 4th Tactical Fighter Wing, and served as vice commander of the 17th Air Force. After retirement, he continued to flourish in achievements. He is an elite test pilot. He was in Tom Wolfe's best-selling nonfiction book, The Right Stuff. He has been featured, recognized, and honored for his accomplishments by such well-respected people as Marshall University, State of West Virginia, President Ford, National Aviation Hall of Fame. So he has an identity that is famous. That's important, I guess. He's taken steps to protect his fame. He serves as a spokesman for AC Delco, and then AC Delco saw sales dramatically increase. He lent his name to computer games, Chuck Yeager's Advanced Flight Trainer, and Chuck Yeager's Air Combat. He has been featured on the cover of numerous magazines, etc. And so then they go into Airbus, and Airbus makes commercial aircraft, defense and space projects, and helicopters. It was founded in 1970, engages in manufacturing aircraft and all that. Let's get to the facts. In 2008, General Yeager visited Airbus. General Yeager is informed and believes that Airbus was informed that for his 2008 visit to Airbus, no video was permitted to be used for sales or advertising unless a deal setting the terms of the same was entered into between General Yeager and Airbus. No deal was entered into, and Airbus was not permitted to use video. And then without permission, he says that Airbus used a video of General Yeager's visit in connection with sales marketing promotion, that Airbus wanted to use his name in press releases, that Yeager demanded a cost of over $1 million, and that Chuck Yeager would have veto power over any specific usage. So if Chuck Yeager didn't like the use, then not only would he get the $1 million, but he would also have the veto power over any specific use. If he didn't like it, he could say no, and they'd have to go make a different use of the video or something. So Airbus declined the fee agreement, or the agreement for the promotional material. And this is important. That was 9 years ago. That was 2008. And then in 2017, they published an advertisement on its website. The publication with the alleged infringing material was intended to highlight Airbus's intentions of making their cost-effective and fast, this is a weird way of phrasing it, highlighted Airbus's intentions of making their cost-effective and fast way to fly with Airbus's racer concept. This is awkwardly worded, Lincoln. The publication seems to be saying the publication was intended to highlight Airbus's intentions of highlighting cost-effectiveness and fast flights. Very strange way of wording that. A copy of the publication is attached as Exhibit A. So here's Exhibit A copy of the article or advertisement. Airbus Racer is a high-speed and cost-effective helicopter. Okay, so that may be why it was phrased so awkwardly. He was trying to say that this concept is for a helicopter. So there's the advertisement. I don't see Chuck Yeager in it yet. Let's take a look. Airbus is looking to make a cost-effective yet fast way to fly through the sky with the new racer concept. Okay, that's why it was phrased awkwardly. And then the text of the advertisement says, 70 years ago, Chuck Yeager broke the sound barrier. We're trying to break the cost barrier. It cannot be speed at any cost, which is something that I think was a quote from Chuck Yeager and his attempts to break the sound barrier, speed at any cost. So they're trying to juxtapose that. Racer uses a main rotor for basic flight, while two lateral pusher rotors provide forward thrust. So it's like a gyrocopter concept. Lateral pusher rotors are installed on the back of a box wing, reducing power required for flight by 10%. This reduction in power also lowers fuel consumption and increases Racer's flight range. All in all, Racer will be surprisingly cheap to fly. Airbus is planning the final assembly in 2019, first flight 2020. And then there's a video and other advertisements, because this is probably a printout from a webpage. I don't see anything from Chuck Yeager in here yet. I don't think there is. So let's go back and look at the advertisement. I'm going to zoom out a little bit. So this is in DuPont Registry Daily, and this is sort of a press release style. And I don't see this video. Maybe he just didn't get it in here, but it looks like there was unauthorized video in 2008, but then where is the unauthorized video in this press release? Maybe let's try this this link here. So this says a clean sheet approach to Airbus Racer high-speed demonstrator. I don't see Chuck Yeager's name on here at all, but this is what he's referring to here. The pertinent paragraph states 70 years ago, Chuck Yeager broke the sound barrier. We're trying to break the cost barrier. It cannot be speed at any cost. Airbus actively took steps, this is the accusation now, Airbus actively took steps to distribute and disseminate the infringing material by utilizing his name, identity, and likeness and federally registered trademarks. Airbus impaired the ability of General Yeager to receive his established earning potential from the use of his name, identity, and likeness and federally registered trademarks. That's it? Like, that's the entire... Really? I was like getting ready for a major like reveal here, and that's it. Let me try this other one. There's another DuPont registry link here.
Isn't the fact that Chuck Yeager broke the sound barrier just a fact? But they're not trying to say that Chuck Yeager represents their company.
Yeah. So here is the live advertisement, which obviously has a lot more advertising on it. And so this is a press release. This is not a article that was written by a journalist. Now that's in favor of Lincoln's case because it is an advertisement. It is definitely not some other person's article that was written. This is an Airbus advertisement. And so Airbus has written, at least to the best of my knowledge, this is written by Airbus. Airbus is looking to make a cost-effective, fast way to fly. And then this is apparently where they used the Chuck Yeager alleged endorsement. Let's watch this video and see if it says anything in here. Maybe it says it in here. Oh, that's not going to help you, is it? I went to go full screen. Oh, it does work in full screen. Okay. A new vision for speed. Safe, simple, efficient. I mean, it's a cool helicopter. Let's give it that. Okay, now unless they edited the video... Wait, there's more. Yeah, this is a PR release from Airbus. So I saw nothing in that video to indicate an endorsement by Chuck Yeager, and it's possible they took the language out of this, but it's not possible that they altered this video. The video at least would have to be deleted and re-uploaded and then a new video put in here. So unless that's the accusation here, I'm unclear what is whether that is actually the entire advertisement or whether there was more infringing material. It does say that the only pertinent paragraph says 70 years ago, Chuck Yeager broke the sound barrier and we're trying to break the cost barrier. It cannot be speed at any cost. That to me does not smack of endorsement, does not seem like a Chuck Yeager endorsed this. They're certainly trying to state a fact and connect themselves with the concept that the breaking of the speed barrier was speed at any cost. and that Airbus has more of a safety idea in mind, especially in light of the Boeing 737 MAX problems. Well, I'm not sure that actually reaches a level of false endorsement. Let's take a look. So California Civil Code provides any person who knowingly uses another's name, voice, signature, photograph, or likeness in any manner on or in products, merchandise, or goods, or for purposes of advertising or selling or soliciting purchases without a person's prior consent shall be liable for any damages sustained by the person or persons injured as a result thereof. In addition, any action brought under this section, the person who violated the section shall be liable to the injured parties of an amount equal or greater to $750, or the actual damages suffered by him or her as a result of the unauthorized use, and any profits from the unauthorized use that are attributable to the use and are not taken into account in computing the actual damages. In establishing such profits, the injured party or parties are required to present proof only of the gross revenue attributable to such use, and the person who violated this section is required to prove his or her deductible expenses. Punitive damages may be awarded. The prevailing party is also entitled to attorney's fees and costs. So at first glance, that sounds like you can't use another person's name, voice, signature, photograph, or likeness in any manner. But this doesn't include any case law that may explain limits, and there might also be a subsequent section that provides limits. He says that General Yeager's name and likeness were utilized. I don't know about the likeness. I saw the name. The commercial value of his name and likeness has been established by prior endorsement agreements. See, the trouble that I have with this is can there really be a law that says that if you use a person's name in any manner in connection with advertising, that means you automatically lose a court case? I can't imagine that that's so, or we would never, ever, 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 ever be able to say a person's name in connection with anything that could be arguably advertising. I really don't understand how there wouldn't be limits on California Civil Code 3334, because that just seems to be way too broad. But they go on about the commercial value and likeness and the $1 million, and they seek general damages, specific damages, punitive damages, and attorney's fees and costs. And then the common law right of publicity, they say that it's unauthorized and unlawful to use General Yeager's name, likeness, voice, identity, and persona. Again, all I saw here was use of his name in connection with the fact that he broke the sound barrier. It did not appear to be used as a way to say Chuck Yeager endorses Airbus, nor did Chuck Yeager appear and say the line himself. So many years ago I broke the sound barrier, and now Airbus is trying to break the cost barrier. That's not what General Yeager said in the thing. He didn't say anything in the advertisement. He said it apparently didn't even appear in the advertisement, it looks like. But we'll see. This is a violation of his general right to publicity under common law, unauthorized misappropriation of General Yeager's rights to publicity, and General Yeager has sustained and will sustain substantial injury, loss, and damage. I don't know. We're going to have to see. See, the standard is going to be whether a jury believes, or I guess it could be a judge if the parties choose. But the standard is going to be whether a jury believes this was a false endorsement. Let's continue. So further, here's the actual false endorsement under federal law. They are arguing that this is false or misleading representations of fact to, and this is conclusory, falsely imply the endorsement of defendants' businesses and products by General Yeager, and that as a direct and proximate result, there's $1 million in damages. And then there's a trademark on Chuck Yeager. Now, this one I think is even less tenable, because we all know that there is such a thing called trademark fair use. You can say compare to Chuck Yeager, or you can name Chuck Yeager as a reference to his product. So you can definitely say the words Chuck Yeager broke the sound barrier. What you can't do is sell a product that makes people think it is sourced through Chuck Yeager, that Chuck Yeager is endorsing or selling the Airbus Racer helicopter. So they're arguing that Airbus has infringed the trademark by using the mark in the infringing material, and more trademark violation because it's a registered trademark and therefore nobody could ever refer to Chuck Yeager ever again in anything is more or less my characterization of the complaint. And then damages, general reputational, opportunity, statutory, special, exemplary, punitive, and restitution damages, and reasonable fees, attorney's fees, costs, expenses, and interest, injunctive relief, and other such relief. I don't know. I disagree. I disagree that such a minimal use stating a fact of American history that happens to include the Air Force pilot's name, I don't see how that's a false endorsement. I am concerned with Section 3344's broad, any use of the name, but that's always going to be boundaried or be bookended or have boundaries set by other laws and by case law. So we'll see. It looks to me, my opinion is that this is a nuisance lawsuit that is meant to convince Airbus, a very large company, that it should just get rid of some money in favor of Chuck Yeager and Lincoln Bandlow, of course. And if they get some money, then maybe they'll go away. The only other fact that I have to reinforce that is that Lincoln files these suits for Greg Lansky by the thousands, nuisance lawsuits that are never really meant to be litigated. Sure, he is somewhat prepared to litigate them. There's still some questions whether Strike Three Holdings and the law offices of Lincoln Bandlow, who left Fox Rothschild, I think voluntarily, one of the largest law firms in the world, so he could pursue his own law firm and continue to represent Strike Three Holdings. So can he really, is this really more than a nuisance lawsuit? Can he really take this thing to trial? And will Airbus really lose on the false endorsement and other claims? I don't know. I am not a privacy lawyer or an entertainment lawyer in that sense. And so I don't actually have a ton of experience or any experience at all with the Lanham Act. That's trademark. I have an attorney for that I use. And the false endorsement is more of entertainment law, and I'm not an entertainment law lawyer. So I will see if I can follow up and find anything else out about Section 3344, or we can maybe do that right now a little bit.
While you're looking that up, I just wanted to make one comparison to a previous story where we covered Ariana Grande and how Forever 21 allegedly used, some of her images and her style and the lighting and all of that to sort of create an association without actually paying Ariana Grande for her work.
Yeah.
And here I think that this is, so in her case, they had tried to negotiate a sponsorship with her, thought that she was demanding too much money for them. They said no. And then they went with a campaign that didn't pay Ariana Grande, but perhaps did infringe on her trademark. In this case, I think it's different where, they knew that Chuck Yeager was charging a certain amount of money for his sponsorships. They decided no. And so they had a campaign that did not rely on his likeness or didn't create a false association. They just stated a fact that anybody can look up on Wikipedia. And to me, I felt like they aren't even getting close to that line of trademark infringement.
Okay, so there was a case in 97 where footage of Fred Astaire was found to be exempt from liability, but that was Section 990, not Section 3344. Kareem Abdul-Jabbar sued General Motors. An Oldsmobile television commercial that aired during the NCAA basketball tournament, Oldsmobile referred in the format of a trivia quiz to an NCAA record, Lou Alcindor's selection as the most outstanding player in 3 NCAA tournaments. The U.S. District Court granted summary judgment to General Motors on the grounds that Abdul-Jabbar had abandoned his rights to the name Lou Alcindor by legally changing his name. The Ninth Circuit reversed. A legal name change is not a defense to a Lanham Act false endorsement claim. We hold that Abdul-Jabbar has alleged sufficient facts to state a claim under both California common law and Section 3344. So that means they could not just get rid of it on summary judgment, and that meant that the parties settled out of court. So yeah, this seems to be sort of a borderline lawsuit that I think Lincoln is hoping to settle out of court as a nuisance lawsuit instead of really wanting to take this to court and figure out for all time whether using a name in reference to a fact is somehow false endorsement. Let's go further. So this is Joe Montana versus San Jose Mercury News. Nothing in Section 3344 does not require consent for use of name, voice, signature, photograph, or likeness, etc., or noting. I hate that word noting because it looks like nothing to me. Noting that Section 3344D does not require consent to use name, voice, signature, photograph, or likeness in connection with news, public affairs, sports broadcast or account, or any political campaign. The posters of the San Jose Mercury News were newsworthy events. So there's news, there's exceptions for news there. And so although the Airbus advertisement did smack of being news, it's probably more of a promotional advertisement than it is news. Here is a person, Mickey Dora, who complained that a documentary misappropriated his right of publicity. He argued that he was never interviewed nor photographed by Frontline, the company who did the documentary, and did not consent to his use of name, photograph, likeness, or voice. Sued him for misappropriation of name and likeness under 3344D. Judge Knott held that Frontline was not required to obtain consent and affirmed summary judgment because the documentary contained matters of public interest and public affairs. So maybe there is something to this. I don't necessarily agree with California's state law that I can never refer to someone else in an advertisement. I would need to be able to refer to other companies and persons' products in an advertisement. And the fact that Airbus is comparing Chuck Yeager's speed at all costs to their not speed at all costs, then I don't know. This one's really on the line for me. What do you guys think?
I think that this is a good example of the Streisand effect, because Chuck Yeager's like, oh, look at them trying to use my name to profit. And I'm like, that's a real nice helicopter.
I know. I want that helicopter.
That is a cool helicopter. And the thing is hearing the thing about Chuck Yeager being in there doesn't change anything for me. Like when I hear that advertisement, I do not think, oh, Airbus got Chuck Yeager's endorsement. Chuck Yeager endorses this aircraft. That's not the connection. But this California law isn't written that way. And that's what's weird to me, is why is the California law written so broadly that I can't even refer to a person having said a thing in an advertisement? So I don't know entertainment law well enough to know whether there is a similar doctrine in entertainment law. The doctrine of de minimis use is a copyright doctrine, and I don't know that it applies any place outside of copyright. The concept of a use that is so small that it is inconsequential, yeah, maybe that's an argument that can be made. I don't know if they call that the doctrine of de minimis use in entertainment law or not. Chuck Yeager was working for the federal government, was working for the people as a test pilot. He was getting paid. And I don't know that you get to own the record in the sense that if he had broken the record privately on his own, I would feel differently about it. But he broke the record in a government plane with government support, with government training, all paid for by taxpayers. So then to say that we can never refer to the sound barrier record having been broken by Chuck Yeager without him getting a private benefit also offends me. I'm okay with him enriching himself in all the direct ways, but this seems reaching, and didn't he break that record with taxpayer help? So I just have a problem with him then saying, I can prevent all of you from ever talking about Chuck Yeager outside of news reporting. No advertisement can ever refer to Chuck Yeager as having broken the sound barrier. Just that sounds wrong. So my gut feeling is that this is a nuisance lawsuit, but I guess somebody who knows Section 3344 better than me, maybe Lincoln, knows it better than all of us. But that still sounds just wrong to me, and I'll be following this one and hoping, keeping my fingers crossed, that Airbus doesn't just settle this, but fights it all the way. But I have my doubts. So let us know what you think in the comments below. I don't really have too much of a legal opinion because I'm not familiar with that Section 3344. If I find something out before this goes to production, then I'll try to include any further research on exactly what the limitations of 3344 are. So that's our show, everybody. Thank you for joining me. I am Leonard French, your favorite copyright attorney. Thank you for your support on patreon.com/ljfrench and sponsors.com/law. This is a community-supported legal education channel. This channel would not be possible without your support and your views. So please like, subscribe, click the bell if you would like to have all of our notifications. Thank you very much to our supporters for the month of September. Thank you to Joshua Davis and TandaPay, who are sponsoring our channel in the month of September. We expect to be done with his video very early this week, so I hope that you'll all get a chance to hear really remarkable ideas that might even apply to lawful masses and legal defense funds. Still working on it. We'll see if we can get something put together for you this week. Thank you to our $50 plus supporters, John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Joe Tyson, and Blackleaf. And thank you to the $5 plus supporters. All of the $5 plus supporters, which includes everybody else, goes on the LED panel behind me as well, now that I'm back in the States. And we're taking the channel to the next level, but we're also overwhelmed with it, so there will be some changes over the course of the next month or so. And I hope that we will be looking back and it'll be a bunch of wonderful changes. So anyway, love you all. Have a great day. Oh, here's a Nico dog for you. There we go. That's better. Now we have Nico. Aha! Oh, just as he wants to get down. Oh, that's my boy. It's my boy. I don't know where Ilse is. She's probably outside. I'm gonna go check on her. Love you all. I'll see you in the videos that drop. Have a great week. Bye.
Don't do that. Yay!
Good kitty.